in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial, we pay the price.
Hello, folks. Wow, yesterday was interesting. Yesterday was interesting. I want to say I'm surprised, but I'm not, because I've been shouting from the rooftops about this judge for months. This was just a matter of time. It's the timing of it that took me by surprise. I wasn't even live yesterday when it happened. I was supposed to do my usual recap because I had work. And all hell broke loose. So today is officially Jeffrey Williams' 764th day in jail. He was incarcerated or put in jail on May 9th, 2022, I believe. I need to check that again. So just Thug in jail. When was Thug? May 2022. I believe May 9th. Not entirely sure. But 760 days in jail. So the Free Thug movement is over 2 years and on day 764. And today is Free Steel, day 1. And yesterday we learned exactly how far Judge Glanville is prepared to go to protect his own ass, to protect the prosecution, how far he is prepared to go to secure a conviction. He was prepared to hold a secret ex parte meeting with a sworn-in witness and did not plan to tell the defense ever about it. And in that ex parte meeting in chambers, which may or may not have been recorded, well, it was recorded yesterday. We will find out if that recording survived the night. I'm not entirely sure because absolutely nothing will surprise me about this absolute fustercluck of a trial. But in that ex parte meeting, we learned at least some parts of it from Attorney Steele that apparently Woody confessed to the drive-by shooting of Donovan Thomas, which is a central part of the prosecution's case. Without that murder charge, they do not have indefinite statute of limitation. If that charge falls, much of everything falls with it. because the statute of limitations has run out on most of the things that happened in 2013, 2014, 2015, and 2016. And what's left? Not that much. And that, I believe, is one of the reasons the prosecution they need every witness, every piece of gossip, everything in order to pin this drive-by murder on Shannon Stillwell. And if Woody confessed while having immunity from the state, how about that? That's reasonable doubt. Because now they have to investigate. Was he there at the time? He probably was, because the state claims him as a witness. Now, Mr. Steele is found in direct criminal contempt to spend 20 days in jail. He will spend weekends in jail. But yesterday he told the judge, can I be put in jail with Jeffrey Williams so we can work? And the judge allowed it. So, and this is a defense attorney everybody should have. And because Mr. Steele, with this, has put himself in the history books, and he was semi-famous before this. He is an excellent lawyer. He has won many appeals, way over the average. He has put Judge Glanville on his ass on, I believe, 2 occasions in the appeals court. Helen asked, why did he totally neglect the reasoning from Ashley? Because Judge Glanville is a victim of his own self-image of infallible. He believes he cannot make judicial mistakes, in my opinion. So, with all the reasoning, with all the case law, with the statutes, with the rules, with the interpretations, he still believes he's right. But to save his own ass, he actually stopped asking for Mr. Steele to reveal. So now he is in direct contempt of court. And which in itself is macabre. Macabre? It's stupid. Ow! Jingles. My leg is still not a scratch pole. Yeah, because Judge Glanville held an ex parte meeting with the prosecution and a sworn-in witness. I doubt there is case law for this situation, because the rules are so set on this that nobody believed anybody could be this corrupt, judicially corrupt, as Judge Glanville. Stacey Fiona asks, is there anything that can be done to recuse the judge? The appeals court. And there are currently, I believe, 2 appeals from Mrs. Steele and 1 from Ashley Merchant, already up in the appeals court. But meanwhile, trial will be ongoing. And here's the fun part. Woody is still on the stand. Woody will be cross-examined. At some point, the prosecutors will run out of questions. They can't postpone this indefinitely. And if I had it, now I'm not there. I can speculate what I would have done. I don't know, but I so want any one of them to, because Mr. Steele is already held in contempt, just to walk up there and fast as hell ask the question, Mr. Woody, did you kill Donovan Thomas? And before the prosecution can stand up, he will shout yes. That would be an interesting scenario. Because then, this faster clock of a trial will take another dimension. Yeah, we are at day 89 of this trial. We are at day 764, I believe, of the number of days Mr. Jeffrey Williams has been in jail. And day 1 of Mr. Steele being in jail. If anybody has a more correct date, please tell me so. But I do believe it was May 9th of 2022, Mr. Young Thug RICO Williams was put in jail for this. Niniola, sorry for butchering your name. We don't know. They can ask for an emergency. Emergency writ of habeas. Then it should take precedent over other cases, and then we are maybe talking weeks instead of months. Sebastian Miller says, I have to salute you, the fact that you can handle this trial. I kind of gave up on it a while back. Yeah, here's the irony. I was preparing for having some variation with a good trial, with a good prosecution, with good facts against a defendant. It is the Florida versus Wade Wilson. Now that will be postponed because I can't leave this trial when it suddenly, because there has been months of absolute faster clock bore fest, and I've been struggling to bring entertainment to my viewers. I've been struggling so hard to just make it interesting, because it really haven't. It has been, look at this photo, look at this map, look at that photo. Let's listen to a jailhouse call when nobody can hear what's been said in it. And it's been like that for months. But, dun dun dun, in comes Woody. And he doesn't play by the prosecution's playbook. And holy crap, things got spicy. Damn, there's a lot of people here. The YouTube things, folks. Thumbs up, subscribe if you haven't. I don't want to repeat myself too often, so please do. Let's see, do I have any coming in the middle of this mess? I'm totally lost. I don't blame you. I've been covering this case for over a year, and at times I'm completely lost because I don't understand how this got past a grand jury. I don't know what lies was told to this grand jury, because it's certainly not evidence they could have presented. It at best, this is like church gossip, bingo gossip, at best. Happy Annie, what do you want to bet this is where it ends in a mistrial? Don't underestimate the judicial corruption of Judge Glanville. He will fight tooth, nail, everything to see this trial coming to an end in a conviction. Don't underestimate him. He is as much part of the prosecution's team as anybody in the prosecution. And he proved that yesterday, beyond any reasonable doubt, that he is a part of the prosecution's team. He actively withheld possibly exculpatory evidence from the defense. That goes to Brady. That goes to fundamental constitutional rights. That not any of you, I hope, as a defendant, the only person in a courtroom with rights are the defendant. Now, that might seem really unfair in most cases, but remember one thing. The judge and the prosecutor are both government officials. They are a part of the government who has the power to put you in prison for the rest of your life and even kill you. That is why the defendants must have rights to stop from to grant a fair trial in front of a fair and impartial jury. And I don't even want the jury to be impartial. I want the jury to be biased towards the defendant. Because the prosecution has all the power. And that is why they have every restriction on them. That is why they must prove beyond a reasonable doubt. That is why they have 100% of the burden of proof. There can't be any other way, because if we suddenly go in, it's 50-50, let's see how it goes. No, because do you really have that much faith in the government? Look around you. You probably know a good bunch of people who are morons. And chances are a few of them are government officials. Should Judge Glanville just call a mistrial? He won't. He will not ever call a mistrial in this trial. The only people who can call a mistrial if a higher court in Georgia forces him to. That's the only way. Judge Glanville has proven over and over and over again, no matter, and I mean, Prosecutor Love, Adrian Love, Solas, Miss Love, have lied to the court on more occasions than I can count to. Openly lied in sidebar and live. She has lied to the court, misrepresented evidence, misrepresented testimony, misrepresented everything, and the judge allows her. And he blames the defense. Each step of the way, he always blames the defense. Remember, this trial was scheduled for 6 months in total. 6 months. We are past 6 months, and the prosecution is not even halfway through their case in chief. This is witness number 80 something out of 209 from the prosecution. And the judge blames the defense for delaying the trial. That is the judicial corruption of this judge, in my opinion. Let's see here. I can see that. Well, the stream is somewhat on, and there is movement. That's there. Now, before, you who are completely new here might be, what's that? What's Jingles, Viking, and Thugs? Well, Mr. Jingles is the leader of our gang here. Let me show you. Hello, Mr. Jingles. Everybody bow for our supreme leader of Jingles, Viking, and Thugs. Look how happy he is when I do this. He's so happy to... Ow. So that we are all Jingles, Viking, and Thugs. So watch out. We might be in a RICO trial of our own. All hail jingles. Yeah. And as Amanda Louise says in the chat, Glanville just got re-elected in May. He is not going anywhere unless he's forced to. Now, yesterday I had Steve Gosney on. He is a Florida-based appellate lawyer. He is death penalty certified, and has been that for quite a good number of years. And he was astounded of what he heard. I also had Ian Ronkel on yesterday, and between us three, I've been doing labor law for over 30 years. I believe Steve Gosney has been doing law for at least 20, 25, and Ian is closing in on 20 years, I believe. So between us, we have 75 years of experience. Is it? Yeah, whatever. A good number of years. We have never seen anything like this. And if you checked around the lawyers in the so-called law tube and everything, nobody has ever seen anything like this. How many errors are we up to at this point? Things I have seen as unforced errors is more than 5, less than 15. For me, it's clear. But that's me. That's my opinion. I have no clue of what an appeals court in Georgia might think. And then you have things like errors that can accumulate to everything being, if they get convicted, there's hundreds of issues, that can accumulate to enough for a reversal. But what happened yesterday, I've heard this from Georgia-based lawyers and lawyers from around the United States. This is, if they get this up to an appeals court, they believe there's a good chance of an automatic reversal. Oh, should we take a poll on this? Maybe. Will Woody plead the fifth? Hold on while I get this started. There. By the way, hello, you over at Twitter/X. You can hit the heart thingy yourself and say something in that chat. You over at Rumble, welcome. And hope to, for you to do the Rumble thingies. Press the thumbs up and everything. How late will the judge be today? Impossible to know. If you have been around for a while, you know that this judge is everything between 15 minutes and 90 minutes late. Would you, won't he? Yeah, yes. I saw Becca. Start a poll. There. Now you have some options as well. Will anybody be in Steele's place while he's in custody, or will he be released while he's representing Thug? he is going to be put in jail during weekends. So he will be in court representing Mr. Williams. And Mr. Williams kind of twisted the judge's arm on this because he made the representation to the court at that he wants Mr. Steele to represent him, full stop. If he isn't, he will not participate. And that kind of twisted the judge's arm as well. All right, the poll is up. And good day, Rumble. Now, yeah, let's do this so I don't have to do it later. Where is it? Where is it? Here is it. Now, if you want to support this channel, there are a few ways to do that. One is super chatting. Most welcome, not necessary. Nothing is necessary, but I would appreciate it. The other thing, becoming a member. That is $3 a month. And you got tons of members-only content. And that is about the farm, the renovations, my personal thoughts, so we get to know each other a bit better. Or you can use PayPal if you don't want to sponsor YouTube, and so because YouTube takes about a 30% cut, while PayPal takes between 2 and 5%. So that is some of the ways. Well, besides thumbs up, watching is number one. Thumbs up, number two, subscribe, number three. And then if you still like me after watching me a couple of times, becoming a member. Okay, that's today's grifting time. Yeah, and we also know that Mr. Steele has good representation in Ashley Merchant. Ashley is, I believe, is the president of the Georgia Association of Defense Attorneys. She is also a member of the Cobb County Bar Association. So if anybody knows what what the state bar can come to when it goes to all of this, she should know. And she schooled Judge Glanville yesterday about what the law actually says, what the ethic rules actually says, and what the statute says. But Judge Glanville is like a 5-year-old with a tantrum caught with his hand in the cookie jar. And he doubled down, tripled down. So even though he violated many of the rules according to the regulations regarding direct criminal contempt, he decided, oh, I'm sorry, and then off to jail with you, more or less. Let's see here. I had closed captions on. Yeah, we are still waiting for things to start. Dun, dun, dun. Let's see. Oh, did I miss out any good questions here? I'm pinning that. Is there anyone in the chat who has iOS? If you want to do the support thingy via iOS, I believe you have to go out of the app and into an actual web page. Then you can support via iOS. That's my memory. And that's my recollection, at least. Let's see here. Paddy B. So let me get this straight. They gave immunity to murder to lock up her. More or less. They gave Woody immunity for what he is testifying about. Now, that is all depending on the questions submitted from the prosecution and the cross-examination from the defense attorneys. And but as we now know, allegedly, we haven't seen the transcript, and Judge Glanville will guard that with his spineless body to never reveal what was said in that ex parte meeting. But according to Mr. Steele, Woody confessed to being the perpetrator of the drive-by that ultimately killed Donovan Thomas. And as I said a few minutes ago, the state's case rests on this murder charge. Because without the murder charge, they don't have indefinite statute of limitation on the rest of the charges. Because then all of a sudden, the individual charges statute of limitation is in place. But since they have this murder charge, everything is resting on that indefinite statute of limitation. Now, do I believe Woody when he says this? No. I think he's trolling, but holy crap. K-squared for $50. Woo! Keep up the great coverage. This case is crazy. Thank you so much, K-squared. Thank you so much. Do I have... I don't have a soundboard or anything. Maybe this.
He's not an idiot. He's just Swedish.
Do I have sound bits? I don't have. I am as technically inclined as a doorbell. On. That's my thing. On, and it should work. And Slidey Pie for $2 over at Rumble for a Rumble rant. Thank you so much, Slidey Pie. Says thanks for all you do. This judge has got to go. I agree, and I said this yesterday. Judge, from now on, the only time Judge Glanville should be allowed into a courtroom in any shape or form should be as a defendant. He's a disgrace for his position. Because the position of judge demands respect, but sometimes the position needs protection from the people who inhibit it. That is also why I am so strongly against this judicial immunity crap that goes on with judges, prosecutors, and cops. I don't see, because nobody should... this is a popular mantra. Nobody should be above the law, as you might have heard lately. Yeah, but why does judges, prosecutors, and cops being allowed to be above the law with this immunity? It's special immunity, qualified immunity, absolute. It's bull crap, all of it. Now, the intentions was good from the start. We can't have people suing prosecutors all the time. So they invented this immunity. But now it is being severely, what you call it? It has been an abomination. Lois Thomas, how long will it take for the appeals court to address these issues? It depends. It could take weeks if they submit an emergency writ of habeas, or months if it is a normal appeal, interlocutory appeal. And also, the judge can stop most of this by not allowing appeals during the trial. Not all of it. But as Steve Gosney said yesterday, he assumes they will submit an emergency writ of habeas. Let's see. How can I explain that? Writ of habeas corpus. Well, let's just say it's a shortcut to the appeals court. That the issue at hand is so severe that it has precedent over other issues that is before the Court of Appeals. Jay-Z said the judge didn't seem to know which contempt he was charging Steele with. Yeah, we saw that yesterday because he was holding him in direct criminal contempt, but he was using the rule set of civil contempt. And because criminal contempt is a punishment. You didn't do that, boom, down you go. It is not supposed to be used to get somebody to do a certain thing. As Judge Glanville told Mr. Steele, just tell me who the snitch is and I will make this go away. No, that's not direct criminal contempt. That is civil. The only civil contempt is used as it was used against Woody. Civil contempt was used against him because they wanted him to testify. That's civil contempt. And the rule set for that. Zach, thank you so much. $5. He should claim his right to an emotional support dolphin, the writ of habeas corpus. Oh, that's good. Oh. Habeas corpus technically show the body, yeah. Show us the evidence. And the appeals court, if successful, they can force the judge to submit the transcript from this. Now, according to the judge and the prosecution, nothing of importance was said. But at the same time, they didn't deny what Mr. Steele said, that he, on information and belief, learned this information, that the judge and prosecution colluded, coerced together in order to get Woody to testify. The judge is not allowed. He can sign the order. He cannot cooperate with the prosecution to get that to happen. He simply can't. And having that in a secret meeting, whatever has bearing to the trial, the defendant have a right to be present. Now, they can claim, oh, but it was a civil matter, not a criminal matter, and therefore it has no bearing on the trial. Bull crap. Because if it was the prosecution and the judge getting in a secret meeting Woody to keep testifying, that has direct bearing on this trial. No matter what Judge Glanville says. No matter what he says. Now, I don't know exactly when this is going to start, because remember, yesterday, this was up for hours. So I thought, let's go back and hear Ashley Merchant. Oh, here we go.
All right, ladies and gentlemen, we're back on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. All right, Mr. Stillwell, Mr. Botts, and Mr. Shar, good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams, good morning.
Acts as nothing happened.
Mr. Kendrick and Mr. Weinstein, good morning. Mr. Ewing, Mr. Matthews Jr. and Sr.,
I
good
need
morning.
to get something to
All
drink.
right, Mr. Nichols and Mr. Garner, good morning. Mr. Ryan and Misty Williams, good morning. Okay, Mr. Smith, Mr. Uhowski, Ms. Knight, Mr. Atkins, Ms. Love, and Ms. Hilton. Good morning.
Good morning, Your Honor.
All right. Good morning to Ms. Halterwinger, and good morning, Mr. Mounsbach, and good morning, Mr. Kokomo. All right. Who? Who are you? Who are you? Okay, all right, good morning, sir. How are you?
And Mr. Jack Pines with us today also too.
Good morning, Mr. Pines. Welcome back, sir. All right, anybody else? Okay. Anything else? Is Mr. Copeland here?
He is.
Okay, can we bring Mr. Copeland back in, please?
I'm back. Yeah, just a normal morning roll call. So let's see what happens this morning.
Do we know if Ms. Bumpus has rejoined us this morning? Okay, all right. Thank you, madam.
Excuse me, Your Honor, may I bring something up before Mr. Copeland comes in?
Go ahead.
I believe I heard him say on an open mic yesterday, gave his testimony that he may take the fifth today. Can you inquire into that prior to the jury coming out?
I didn't hear him say that, but I can.
Thank you, Your Honor. Your Honor, also.
Pieces of business I have to do, at least for the record, renew our motion for a mistrial.
Denied. Okay,
Thank
what
you.
else?
And also, again, requesting, for the purposes of cross-examination, the transcripts from yesterday.
I'm deferring on that one for the time being, okay?
Thank you.
All right. Can we, you have something, madam?
Yes, Your Honor. I just wanted to say for the record that that is not his position. He explained yesterday, I believe that he had,
You talking about he being Mr. Copeland?
yes, what he said, and I was standing there when he said it, was that his head hurt. And if y'all don't let me go, I'm about,
Is this at the end of the day?
yes.
Soulless Miss Love, Satan's whore. You are in no position to make claims on what he said or didn't say. That is for the record keeper to say. You don't, in my opinion, you lost the right to be an interpreter of anything. And you lost it a long time ago.
At the very end of the day, he did not state without qualification, I'm going to plead the fifth. He said, if y'all don't let me go, I'm about to plead the fifth again. That's all he said. Ms. Hilton has been speaking with him. He has given her no indication that that is his intent.
We'll find out.
fine.
We'll find.
Oh, so the prosecution are continuing the collusion and the coercion into Woody. Good to know.
Not before the jury comes in. All right. Where is he?
Should be on his way in.
All right, seems like Woody is taking the stand. Let's see what happens today. Oh, for you who don't know, Woody went home yesterday. No longer in jail. No longer in civil contempt. Isn't that strange? If nothing happened in that meeting, then why was he let go? Why was he let go? Now, they can claim, oh, it's because he started testifying. Yeah. Do you really want to take that risk? No, they did something.
Mr. Copeland, good morning again, sir. Sir, could you approach the witness stand, please?
And Woody's trolling of the court continues. one. I'm having a vanilla cinnamon bun.
Mr. Copeland, again, good morning, sir, and you're still under oath, okay? Yes?
Okay.
Okay, all right. Sir, is it your intent to continue to testify today, sir?
Yes.
Okay. All right, summon our jurors, please. Okay.
Yeah, that's me fast forwarding here.
All
Every
right,
time
thank
I
you,
talk,
Sergeant
we
Brown.
get 30 seconds behind.
Ladies and gentlemen of the jury, good morning. Good morning. All right, we're gonna pick up where we left off yesterday, all right? Ms. Hilton?
Thank you. Mr. Copeland, good morning. Good morning. Yesterday, when we left off, you had spoke about some pictures that were blurry to you. Do you recall that? Yesterday?
I don't recall it.
Okay, let me show you some pictures again then. Permission to approach, and I'll show the defense counsel again.
Gotta show that to them first, please.
Slidey Pie over Grumble asks, can still ask what if he met with the judge and love? On cross-examination, if allowed, I have a strong feeling that the judge will strike down any attempts to find out what was said in that meeting.
Showing you again what's been marked as, showing the defense counsel as State's Exhibit 342, Yankee Oscar.
Oh,
First,
great.
let's start there.
More Instagram
Are
photos.
you able to recognize anybody in 242 Yankee Oscar?
Nope.
And why is that? Do you not know anyone, or because you can't see it? Why can't you?
Objection, Your Honor, ask and answer, you say you recognize.
Oh, sir.
Why can't you recognize what's in the picture?
What you mean?
Do you not see it? What do you mean when you say you don't know who?
I can't recognize the picture.
Do you see yourself in that picture?
No.
You do not see yourself.
The picture blurry.
Showing you, and the description of what's going to be marked as 342 Yankee Oscar. Looking at what's on the computer screen and in front of you, does that appear to be the same picture?
Yeah.
Now, have I just zoomed that picture in?
Yeah, you zoned it in.
Okay, now that it's zoomed in, are you able to identify, looking at what's on the screen, who's in that picture?
Yeah.
Okay, who's in the picture?
Me?
Anyone else?
Yeah.
Who?
Shana and D.
Okay, which D? Is that the little D we were talking about yesterday?
Yeah.
Okay. And does that, all right, Your Honor, this time the state would like to tender 342 Yankee Oscar into evidence.
Any objection to the state's 342 Yankee Oscar?
Yes, Your Honor.
Basis?
It's 342.
Overruled, sir. It's admitted over objection and may be published as you see fit.
All right. Next, I'm gonna show you what's been tendered and showed to defense counsel is 345 Yankee. Do you recognize anyone as a 345 Yankee?
Yeah. For you who don't know, this is the absolute epitome of the state's case. Do you recognize yourself in these pictures?
Oh, yeah.
Who are the others? And then the allegation is, well, that proves they are a criminal gang. It's
Me and a couple people from my neighborhood.
Who are those couple people from your neighborhood?
Lil D, Dunt,
Anyone else?
from this picture. Yeah. And another guy, he ain't from my neighborhood.
Okay, do you know his name? Or his nickname?
Richie.
All right, anyone else?
He looked like Shannon in the picture.
Your Honor, this time the state like attended 345 Yankee attack.
Any objection to 345 Yankee?
Just one clarification, are these 345 Yankee O or 345 Yankee?
It'll just be 345 Yankee based upon we not having to protect it.
Okay. Just, cumulative, Your Honor.
All right. Noted. I'm gonna admit it over objection. That can be published as you see fit.
Thank you, Your Honor. Next, I'm gonna show you what's been marked as 356 Yankee Oscar.
Me and Shannon.
Your Honor, this time the state like attended 356 Yankee Oscar to evidence.
Any objection to state's 356 Yankee Oscar?
Cumulative, Your Honor.
All right, noted again. I'll admit it over objection and may be published as you see fit.
Next is 346 Yankee. Do you recognize anybody in 346?
Me, Shannon, and D.
Your Honor, this time the state would like to admit 346 Yankee into evidence.
Any objection to state's 346 Yankee? Sir,
Cumulative and 440.
can I see it, please? I'll note your objection, Mr. Short. Overruled. I'm gonna admit it over objection. It may be published as you see fit.
Thank you. And the
And for you who don't know, Mr. Short is Mr. Stillwell's lawyer, Shannon Stillwell's lawyer, and he spells his name SHARDT. I may have made fun of his name the first few months of me covering this trial because the names in this trial I find amusing. You have Prosecutor Love, Attorney Short. We even have an Assistant District Attorney Sprinkles. Not joking. And he will probably be up for testifying regarding the Donovan Thomas incident this week, because he was the Assistant District Attorney who decided to drop the charges against Mr. Stillwell twice. Vince Clotho became a member. Welcome to the Viking crew. Welcome. Thank you for your support of this channel. I'm very deeply appreciative of that. Thank you so much.
Last two, Mr. Copeland. It's gonna be 357 Yankee and 374 Yankee. Those
She
are
found the
last two.
microphone.
Same three.
Would that be you, Shannon, and little D?
Yes.
All right. Your Honor, this time of state would like to tender 357
I'm
Yankee and 374 Yankee into evidence.
Let out the hair.
Sir, any objection to 357 Yankee or 374 Yankee?
I say that again.
357, you want this, 374, you
Let me take a look at 374, please.
Ozzy!
Um,
Ozzy!
I note your objection again, Mr. Sharp.
Ozzy Overlord gifted 10 memberships. Thank you so much. Can I send you a link or are you going to bed? Well, he gave it to Louis Thomas, Whiskey 77, Papa G Gross, Melissa Simok, Ella Wishes, Carolyn, Code Heidi, Bree H, Susan Lee, Mr. E409. That's a preservative for E409, if I remember correctly. Thank you so much for your support. And now you named are also have access to my members only content. And there are over 50 hours just for you, at least. Thank you so much, Ozzy. I will send you a link. Dun, dun, dun. Where are you? Where are you? Where are you? There you are. Now, it's in the middle of the night there, so he's perfectly excused because he just went through. He just went through yesterday on his channel. So everybody, if you haven't subscribed to Aussie Overlord, you need to do that. His news thing he does, law, news, and laughter. Is that? Oh, I'm a bit stupid today. I had roughly 2.5 hours of sleep last night, so I'm in a bit of a daze, so to speak. Law, news, and laughter. Yeah, that's amazing. Almost daily. You need to follow that. But we are here for the Young Thug trial, so let's continue.
I'm going to admit them over your objection to States 357 Yankee and States 374 Yankee, and they may be published as you see fit.
First one published, States Exhibit 342 Yankee Oscar. Now, looking at States Exhibit 342 Yankee Oscar, Mr. Copeland, are you able to see the date that's on the bottom right-hand side?
No.
All right. If you can zoom into the picture, please. Are you able to see the date now that is zoomed in?
It looked like it said 2014.
Okay. Does it say October 26th?
I guess. Yeah, I guess.
All right. Now we can scroll over to the picture. Now you can tell the jury from left to right who's all in that picture.
From left to right? Who left and right? From my right?
Yeah, we can do it from your right.
D and Shannon. I don't know the boy next to me.
Okay, you don't know who that is.
I don't know him.
All right. And so is Shannon the person in the white tank top sitting on the car?
It looked like it.
Okay. And is little D the one with the gray hoodie and the backwards cap?
The who?
The backwards hat.
Yeah,
All right. And then is that you with the hand symbol?
that's me throwing up.
Are you saying that what you're throwing up is the peace sign?
I'm saying that's me right there.
Okay. What are you throwing up, and
What you mean what I'm throwing up?
what is that? Is there any significance about your hand sign?
Not to my knowledge.
Not to your knowledge. Okay. Any particular reason why you have like a Y and an L?
A who?
What appears to look like a Y and an L.
Nah, I throw signs every day. They don't.
Okay. Next, looking at 345 Yankee. If we can zoom in.
Yeah, folks, there's a
Is
lot of
that
it.
you in the black leather jacket and the white t-shirt?
And the first few weeks of this trial, colors of clothes were so important for the prosecution. Ironically, most of the time, the prosecutor Love and ADA Hilton was wearing the same color. And often it was red, which they claimed, while wearing red themselves, that, oh, that is a sign that you're a part of the Bloods, isn't it? And I just sat there, this is stupid.
Is that you?
That's me right there.
Okay. Who's standing next to you with the hat and the hoodie on in black?
Richard.
That's Richard to the left of you.
Yeah.
Which one is Richard? Okay, so the one standing with just the hoodie on, is that who you're pointing to?
You said to the left of me, right?
My left, but what are you considering?
My left. So this is my left, right?
Okay. So
So
that
that make him to my left?
if you're looking at it in that direction, yes. All right. Who's to the right of you then?
It looked like Shannon.
All right. And then who's the individual in the Bout That Action Rich Gang sweatshirt?
Say that again.
Who's, he can't, you can turn behind you. Who's in the red hoodie?
It looked like Lil D.
All right. And do you know the other individuals, the other three males, do you know them?
The one looked like Dunk.
That's Don. Okay. And what about the two behind?
I don't know them.
You don't know them. All right. Thank you so much. Now publishing 356, Yankee, Oscar. Who's there with you in this picture?
Can you fix this?
We are 4 minutes behind, so I can speed this up to 1.25. On the morning break, you know that
Who's
Judge
Shannon?
Glanville will
Shannon,
take
right? Now looking
occasional
at 357,
10 minutes
Yankee Oscar.
breaks that are 20 minutes long. I have Judge Glanville's
Excuse me, not
order
Yankee,
of
357 Yankee, I
contempt
apologize.
ready,
Is that you, Shannon, and Little D?
and how
I
the
know you said yes,
reply
but you didn't
might
say.
be.
Okay. 346 Yankee.
Because I've seen from attorney
Same. Is that you, Shannon, Little D?
Andrew
Yeah.
Fleischman,
Right. 355 Yankee.
is from attorney Andrew Fleischman, has done his research, and he claims this contempt cannot survive on its face an appeal. So in the next break, that is what we will going through. We'll be going through.
Again, the same three, you, Shannon, Little D?
I thought I told you yesterday.
Okay, but you didn't tell the jury. So is that the same three people?
It's the same.
Okay, and then last but certainly not least is 359. Again, the same three individuals. Is that a yes for the record?
Yeah.
Thank you. Let's hit it down. Now, do you, Shannon, and Demikian have the same relationship today as when you took any of those pictures that we just looked at?
That's the answer, Your Honor.
I stand in objection.
Ooh, it's a rare sustained objection.
Do you know someone by the name of Diamante Kendrick?
Street name.
Diamante or Yak?
I know of them.
You know of them?
Yeah, I know of them.
When you say you know of them, what does that mean?
I know of them. Like,
Have you ever met them before?
yeah,
Okay. Have you ever spent time with them before?
I've been around.
Okay. Do you see that person in the courtroom today?
Yeah, he's a rapper.
Okay, that's fine. He's a rapper. Do you see him in the courtroom today?
I said, yes, he's a rapper. I see him in the courtroom. Yes.
Okay, you can identify him by article of clothing that he's wearing.
I think gray and white. White and gray, I don't know.
Where is he sitting next to someone?
Yeah, he's sitting next to the white man.
Yeah, please let the record reflect that Mr. Copeland has a
That is almost all of them. I believe 2/3 of the lawyers are white. Oh, that was funny.
identify Mr. Kendrick.
It shall.
And do you know what do you call him?
By his rap name.
What's that?
Yeah, got it.
Okay. Is Yet Gotti from Atlanta?
I don't know.
How did you first meet him?
I don't know.
Did you all go to school together?
Nope.
Are you sure the two of you did not go to school together?
Actually, that's the answer.
I stand in objection.
Do you recall previously stating that you all went to school together?
I never went to school with him.
Okay. About when did you first meet him?
When I first meet him or when I first started hanging with him? Been around anything.
I'm going to ask first when you first met him.
What's your definition of meet?
Woody is still trolling the prosecution. Now, I get the question over Rumble and here on YouTube. What does this prove? Well, the Georgia RICO is so broad and so vague that it is enough for the prosecution to prove they hung out semi-regularly. Because in the Georgia RICO Act, if they can establish that this is a criminal street gang, what one person does over here, which is a car theft, then everybody in that gang under the Georgia RICO Act are collectively guilty. If they can prove another guy over there committed armed robbery, everybody's guilty of the charge of being a criminal street gang under the RICO Act, a criminal enterprise under the Georgia RICO Act. And that is why they have so many people testifying about who do you know? Who have you hung out with? Who did you make the hand signs with? Did you attend a concert? That's enough, according to the prosecution, at least, to put this case in front of a jury and hope for a conviction. My dream, my not so secret dream, is when this trial is done in about a year and a half, the jury will take 45 minutes and come back with a not guilty verdict.
When's the first time you remember meeting him for the first time?
Where I come from, we hear of people before we meet them. So I don't know, like, I don't know what you mean meet. Like, I heard of him.
When is the first time you heard of him?
Through a friend of mine.
Okay. About how long ago was that?
I can recall.
Right. If this year is 2024, was it when you were in elementary school, middle school, high school, adult life?
When I was done with school.
When you were done with school? You said you met him through a friend. When did you all start hanging out with each other?
Like, what you mean, personally?
Yes.
Thank you. Thank you so much. Yeah. Now, this is a replica of a 13th century North Germanic chieftain, what his helmet was. And this is actually, now you can't see it from that distance, but this is actually full size. And it's full size to my head. And I have a huge head. Phrasing. No, I think my hat size is 7 7/8 or something like that. So yeah. I like my medieval things.
We didn't hang like me, Shannon, and D did.
Okay. So it wasn't like you and Shannon and Dee, but did the two of you hang out together?
We done been places like in the club, but we never rode in the car together.
Okay. Have you ever been anywhere else besides the club together?
Yeah, studio. I've been in the studio while they was in there recording.
Have y'all been anywhere else together?
I don't recall.
I know you said you all been out together. Have you all ever communicated with each other on the telephone?
Not that I can recall.
Have you ever communicated with him with FaceTime or any other video chat services?
I wasn't clear.
That wasn't my question. So I'm asking you a different question.
Ask me, have I ever communicated with him on telephone, right?
Have you ever spoken with him on the telephone?
I don't recall having no conversation with him on no phone, none of that.
Okay. When was the last time you remember going out to the club or hanging out with him?
As in, what you mean?
You said that you would go to the club, go to the studio. When was the last time you've been to the club with Yak?
Last time I've been in the club with him, we didn't go to the club together.
When's the last time that you've been with him at the club together?
I can't recall no specific date.
Okay. Was that this year in 2024? Just yes or no?
No.
What about in 2023? Yes or no?
No.
Okay. What about before 2015? Because 2015 you went to jail, right?
So what you mean before 2015?
So where you went to jail June 2015. You spent 4 years in jail, right?
I did.
Okay. So I'm asking you, before you went to jail, do you think that was the last time you were in a club with him?
No, I saw him in the club and like when I got the feds.
Okay. So sometime in 2019.
Yeah, I guess.
All right.
2020, I don't know.
All right. When was the last time you've been in the studio with him?
a long time ago.
In those times that you have been, in and out of jail, have you ever spoken to him while you were in jail?
Not to my knowledge. I can't recall if I have or haven't. I don't know. But I don't believe I have.
You have permission to approach.
Woody has been in jail or prison a majority of the time between 2014 until last year, I believe. What? Ah, crap. I put the wrong... I pressed the wrong button and we got back to the start. Well, more pictures.
I'll show you what's been marked as 375 Yankee, 376 Yankee, and 377 Yankee. First on the 375 Yankee, do you recognize who's at 375 Yankee?
Which one is 375?
Cinema buns and orange juice. Yeah.
Mm-hmm.
Often a snack.
This 375?
Yes.
Yeah, I recognize.
Who's in 375 Yankee?
Me and Yet got it.
All right, look at 377 Yankee. Do you recognize any addition to 377?
Yeah.
Who is that? Who is in 377 Yankee?
Me Yet got indeed.
Okay, and look at 376 Yankee. Do you recognize the people in 376 Yankee?
Me and Yet got it.
All right, you're right. This time it's stay like the 10 or 60, 375 Yankees, 377 Yankees, and 376 Yankees.
Any objections to stage, we'll just do it by the numbers. 375 Yankee, anything?
Yeah, objection to 375 Yankee
Faces.
under 404B.
Let me see it, please. Can I see them all? 375, 376, and 377.
I have no objection to 376 or 377, Your Honor.
All right, then anybody else? Then they're admitted they're admitted. Council Skill approach, please.
Are they going up? Are they going up? They are going up. That gets us to, for you who are regulars, you know what's about to happen. It is sidebar counter 203. Yes, in this first clock of a trial, we have over 200 sidebars. Now, you might think day 89, that not so much. Yeah, here's the thing. In those 89 days are hearing days, which we had, I believe, somewhere between 7 and 9 of them. All right, we're down to day 80. Then you have half days, which we have had roughly 20 of. All of a sudden, we are down to 70 actual trial days. Now let's count in. Judge is always late, from 15 minutes to an hour and a half. His 10-minute breaks are at least 20 minutes, and his 1 hour lunch is always at least 90 minutes long. We are probably around day 55 to day 60. And now count in 200 sidebars. Oh. Skip ahead, skip ahead, skip ahead.
States 375. States 376 and 377.
Commissioner Parmesan.
Yes, the policies you see there.
First start with 375 Yankee. And is that you and that guy who identified?
Yeah.
Okay. Now look at 376 Yankee. Same, is that you and that guy?
Yeah, we at the club.
Okay. Then look at 375 Yankee. Are y'all at the club at 375 Yankee?
No, we outside the studio.
Okay, that's where the studio is. Where's that studio?
That one was in Pittsburgh.
In Pittsburgh. And you know what street that is? What street in Pittsburgh that is?
I'm from Kenneth.
I know you're from Kansas. You said that was in Pittsburgh.
Right. I just know, I don't know how the streets in Pittsburgh.
Okay. All right. And next at 377 Yankee. Tell Drew who's all in that picture.
Me, yeah, got it in Liddy.
Do you know the, let me ask, is Lil D the individual with the gray cat on his head?
Yeah,
All right, and is you, yeah, the person in the middle with the beige
Sorry.
cat on his head?
yeah.
And then you the person taking the picture,
Is that what it looked like?
okay? Is the person behind you, you got no names,
I never seen him day in my life.
except for this picture?
Folks,
Yeah.
this is
Well, I really didn't even notice him.
the evidence the prosecution brings
Do you know
forward.
where you all are in this picture?
This
We
is
have to
it.
be at the studio.
That is the studio too?
I don't
Or
recall
they
the picture.
have some jackass claiming, oh, it was a Pontiac. Say what now? Remember, in the prosecution's charge, a charging document, it is stated that the drive-by car was an Infiniti. Why? Because young Thug rented an Infiniti. Once they showed the videos, there was a Infiniti in one of these videos. You couldn't see the driver or anything. Then in a Pontiac, you saw, I believe, Stillwell, was it? I don't remember exactly. And then they showed the video from the actual drive-by shooting. There is no way in hell that car they showed was a Pontiac. Why? Because the grill bar was in the other direction. So it was neither a Pontiac nor an Infiniti.
Now, do you and that, let me start that. Do you know roughly when any of those pictures were taken?
What you mean?
Like time frame, year that those pictures were taken?
Yeah, like way back in like 14, 13, 14.
Do you and that have the same relationship today that you all had back in 2013, 2014?
I don't get what you mean.
Sure. Back in 2013, 2014, we see that there are a few pictures of you and Yet together. Is that fair?
Oh, okay.
Right?
I assume this is legal news. Hunter Biden guilty on all charges. Federal jury found Hunter Biden guilty on all 3 federal felony gun charges he faced, concluding that he violated laws meant to prevent drug addicts from owning firearms. So, yeah. Let's get back to trial.
Today, or recently, Do you all hang out as much as you did back in 2013, 2014?
All our records are not development foundation councils.
I completely missed
Back
that.
in 2013,
The rolling
2014,
thing
is that when you all would go to the
instead
club
waiting
and go to the
for the
studio?
court to start.
Yes.
Okay.
No, like 2014. Me and Yet didn't go to no club in like
Oh.
to like 2014.
It's a
Like
recap.
I think
Okay. So 2014,
I got out of jail 2013.
all right. So after you got out of jail, is that when you began going to the club?
No, I was going to the club before then, but I met Yet. I think like 2013 when I got out of jail or 14.
Okay. Once you met Yet,
I don't really know yet. Like
I understand. Listen to what I'm about to ask you. Once you've met him and y'all started going to the club, whether that's in 2014, around that time, my question for you is, do you all have the same relationship today that you all had back in 2014 when y'all were going to the club and hanging out?
Asked and answered on Friday.
You're right.
I don't know what you're asking me. I don't know how to answer that. I don't know I don't.
Do you still go to the club with Yet Gotti?
I don't go to the club, nobody.
Okay.
I don't go to the club, period.
Do you go to the studio with Yet Gotti?
I don't go to no studio, period. I don't even leave out the house. I stay in the house all day.
Okay. When's the last time you spoken with Yet Gotti? Have you spoken with him this year? Yes or no?
How could I answer that?
Do you recall speaking to him in the year of 2024?
I don't speak to nobody.
Okay. In 2023, do you recall speaking to Yet Gotti? Yes or no?
I don't think I spoke to him in 2023.
Okay.
I remember seeing him at a club in 2019, 2020, not 2019, like 2020.
Okay.
Whichever one of the years I was out.
All right. And when you saw him in the club, did you speak with him?
I was trying to become an artist. I was trying to become a rapper. I saw him and he was giving me advice on what I should do and how I should go forward with it.
Okay.
And he was trying to encourage me to do it.
To rap. That's in 2020.
This one of them years.
One of them years. Since that conversation when he was encouraging you to rap, have you had any other conversations with him?
I went back to jail.
Okay. Since you've been out, any conversations with him?
Well, he been.
Yes or no? Yes or no?
What? Yes or no to what?
Since you've been out of jail, since 2020, yes or no? That's all I need. Have you had any conversations with Yet Gotti?
Not that I remember.
Okay, thank you. Next, do you know someone by the name of Jeffrey Williams?
The truth as how is this not cumulative at this point? Multiple pictures involving the same people to show relationship because the judge says so. That's the only answer I can give because spineless Judge Glanville says so. It's not cumulative. I wish I had another answer. I wish I could give you a legal analysis. I wish I could give you a set of rules to show you. I can't. All I can say is because Judge Glanville says it's not. Regardless of what statute or law or rules say. It's his courtroom. And no matter how bad this becomes, it's his courtroom. And unless somebody forces him out, he will stay there. And I mean that judicial.
I heard of him. He's a rapper.
Okay. Do you know?
I know him. I don't know him as Jeffrey Williams. I know him as Young Thug.
All right. And when you say you know him as a rapper, have you ever spent time with this individual?
Yeah, I did.
Okay. When is the first time you recall? Strike that. What do you refer to him as?
Young Thug.
Okay. When's the first time that you recall meeting Young Thug?
At the studio.
And roughly what year are we talking about?
Before I went to jail.
Which time?
Right. Before that, I went to the feds.
So before 2015. Do you see him in the courtroom today?
Yeah.
Can you identify him by article of clothing he is wearing?
Brown. With dread, sitting next to the bald head guy.
All right, is anyone else on the other side of him?
I will stipulate Mr. Williams, sitting next to him.
Okay, all right.
Thank you. You said that you met at the studio. How did you meet him at the studio?
Through a friend.
What friend?
I really didn't meet him. I just saw him at the studio when I was with a friend.
What friend were you with?
And I asked him, can I take a picture?
What friend were you with when you saw him at the studio?
Doc.
Was it anyone else?
Huh?
Was there anyone else?
There's a lot of people there. I don't recall who all the people was.
Do you recall if Tick was present when you first met this young Thug?
I can't recall.
You said that you met him at the studio and you asked to take a picture with him. You're right, I'm looping the questions. I can get to my next question. When you met him at the studio and you took a picture, did your friendship or relationship develop after that time that you met him in the studio?
What you mean?
Did you all develop a friendship?
Did we develop a friendship?
Yes.
My definition of a friendship is not just knowing somebody or knowing who somebody is.
Okay. Did you start hanging out with him?
I started going to the studio a lot.
Okay. Did you start hanging with him outside of the studio?
I have.
Okay. When you hung with him outside of the studio, where type of places would you hang out with him at?
But most of the time, he liked to be in the studio.
Okay. My question is, when he was not in the studio and you hung out with him, where would you hang out with him at?
We used to do fun stuff, like go to like bowling alleys and stuff like that. He went to the kids' football game, I remember.
I forgot. You who just became members, thanks to Aussie Overlord and the rest of you who are members, you have members only emojis. Here they are. Here are the Vikings. Here is when I boomer and mute myself and keep talking. This is my tractor. He made Viking. What you see there is the three-hole wonder. That is the nickname Travis Alexander had for Jodi Arias. The trial I'm covering on Saturdays with Dave over at MLS God of Law. Then Mr. Jingles and Christmas jingles.
I've been to the club with him.
Yes, Vince, it's a bowling ball. That's the pun. It has 3 holes, as in a 3-hole wonder.
I've been on shows, I mean, I'm correct it.
You said on shows?
Yeah, like when I watch him perform.
All right. And is this the shows, the bowling alleys, the club, are we talking about in 2014, 2015, or some other time?
2014 only.
2014 only. In 2014, about how often would you see each other on a monthly basis?
I don't keep up with that type of stuff.
Okay. Did you see him a lot in 2014? Was it quite often? Were you always around? Or did you see him once in a blue moon?
Well, to know that he was a rapper and successful, I seen him a lot. To me, I think I saw him a lot.
Are you referencing like seeing him on television or being around him in person?
What you mean?
You just said, because he's a rapper, I saw him a lot.
Yeah, because you don't see rappers a lot. So,
and I'm sorry, I just want to clarify. When you're talking about seeing him, are you talking about physically being in his presence or seeing him like on television?
I knew people that be around him.
Okay.
And I used to see him a lot. Every time I see him, I saw him.
All right.
I was happy to see him.
Besides seeing him in person, would you ever speak with him over the phone?
Meaning,
Did you ever talk to him? Let's first start old school. Pick up the phone, dial some numbers. Would you ever talk to him over the phone?
have me and him had conversations?
Yes.
I can't recall if we did or didn't.
Let me ask you FaceTime. Have you and Mr. Williams ever FaceTime with each other?
I know
I can't recall.
this is boring, but we have to get through all of this, and sooner or later the prosecution has to stop asking
Let me just ask
questions
you
and
generally,
time for
in 2014,
cross-examination.
with any of your friends, Shannon, Little D, Yak, or you said you didn't speak to Yak, would you FaceTime any of them?
Say that again.
Shannon and Little D, would you FaceTime them back in 2014?
I don't like FaceTime.
I know you don't like it. That's not my question.
You know what I'm saying? So most of the time I talk on the phone, I call regular.
Okay, but have you?
I don't recall talking on FaceTime.
You don't recall talking on FaceTime?
Not that I know of. Not that I know of. And I don't. You have to ask that again because I ain't for sure what you're asking.
Sure. I'll ask you again. 2014, 2015, have you ever, I'll wait till you finish.
I'm tired.
You and I both. Okay.
I stand the objection.
Back in 2014, have you ever FaceTimed with Little D? Ever? Back then?
Lil D?
Little D.
How I supposed to remember that?
Do you recall ever FaceTiming with Little D?
I don't.
Okay. What about Shannon?
I don't.
Okay. What about the person you identify as Young Thug?
The person identified as who?
Young Thug.
I don't.
Okay. What about you said no to Yak?
If I FaceTime with him, I probably screenshot it and post it on social media just to show people that I probably was on the phone, but I don't remember if I ever did have it.
Okay. Now you said that you would spend time with him, whether it's a studio or.
Do I know what this is leading to? I don't. For me, they have established acquaintances, which, according to Georgia RICO, is enough to get certain evidence in. And then it is up to the jury to interpret that evidence. There has to be somewhere they are going with this. Otherwise, why are we still here listening to him trying not to answer questions about who he FaceTimed, who he called? But it's the prosecution's case, and we know that Judge Glanville is part of the prosecution's team.
In other places, were you close to Young Thug as you were Shannon and Little D?
That's not established under a foundation.
I stand the objection.
Did you speak often with Young Thug back in 2014? Did you talk to him often?
Not that I recall.
I think you recall. You have permission to approach?
You may.
I'm showing defense counsel what's been marked as Stacey David 348 Yankee. And we are going to move to admit excerpts of what's already been admitted, which is going to be 164 Echo Golf, 164 Echo Hotel, 164 Echo Juliet, 164 Echo Kilo, 164 Echo India, and that's it.
Hello, Gigi. Oh, hello, the Ghost. Sorry. Hello, Ghost. Woody didn't want to testify in this trial because he's testifying after the secret ex parte meeting. No, the ex parte meeting was yesterday. He started testifying Friday. And, well, they got 3 questions. Oh, no. It's Tuesday. Yeah, Friday. And on the 3rd question, he pled the 5th in front of the jury, and he was sent to jail. So he was compelled to testify. his lawyer claimed he's pleading the fifth. And that is when the prosecution gave him immunity. And that apparently eradicates the Fifth Amendment right. And here's my criticism of that, because a local prosecutor can only offer immunity for that county. The judge doesn't have jurisdiction of more than that county. Now, if the Attorney General is involved, yes, then it goes statewide. But it does not exclude federal crimes. So if Woody is up there and hypothetically he has to answer the question, who did you receive those drugs from? And he says a name. And the feds know, well, that person took it over a state border. Boom, federal crimes. So I think it's ridiculous that the Fifth Amendment right can be erased completely by a local prosecutor offering local immunity. It's absolutely horrific. And they are back at looking at more pictures she once admitted, I assume. I'm not sure. His lawyer, his main focus was that the prosecution contacted his client without his knowledge. And the prosecution said, well, when we talked to him, he said he didn't have a lawyer. And my response to that would be, well, you didn't know that, so why did you contact him directly to even ask that question? You're not supposed to, if you know that because Woody was involved in this case early on, and at that time he had representation. And still the prosecution chose to ignore his lawyer and talk directly to Woody, which is a clear ethics violation. And Woody's attorney said he would report Miss Love to the state bar. They are taking good time to go through this. Skipping ahead, and that's the Wall of Doom. They seem to be ready to go with more pictures.
Yes, ma'am.
Yay!
Mr. Copeland, I want to show you what's been marked as B48 Yankee, 368 Yankee, 369 Yankee, 370 Yankee, 371 Yankee, 372 Yankee, 373 Yankee. First starting at Bill, can you take a moment, just flip through all of them and tell me if you recognize the people in all those pictures.
What you want me to do?
Go flip through and just tell me if you recognize the people in those pictures.
Yes, GD. She says, I wonder if they will ask if he's afraid of Thug. Of course they will. At some point. But I see nothing of him going to... First of all, it's objectionable. And it should. And by the way, everybody, this is Gigi, my first and best moderator. She has been with my channel for almost from day one. And she is an integral part of this channel and its growth and how the chat is moving along. So everybody say hello to Gigi.
Yeah.
So we're gonna stop there. Look at 373, Yankee, do you recognize who 373?
What about it?
Who's in the picture?
It's Glory.
That's one. 372 Yankee, who's in 372 Yankee?
Now, Gigi has only
Yeah,
once
got it.
or
You got it.
twice dropped her phone behind the couch and accidentally muted people. That don't hold that against her.
Other people in that picture.
It's like the other artist, Duke.
Okay, anyone else?
I seen this guy, but I don't know him.
You don't know him?
Yeah, I seen him, but I don't know his name.
Okay. All right, you're on this time to stay like the Tennessee Exhibit 372 Yankee into evidence.
Any objection to states 372 Yankee?
May I have Mr. Williams?
All right, hearing none, 372 Yankee is admitted, may be published as you see fit.
Next, I'm handing 371 Yankee. You recognize the 371 Yankee.
Yeah,
Who is it?
me and Young Thug.
You're on this time to stay like Tennessee Exhibit 371 Yankee.
Any objection to states 371 Yankee?
Papa G. Gross is completely correct. It's to every question here is to establish his connection to known gang members, and his actions were in furtherance of that gang. Once established, his recorded statements against other members can be testified to. So everything we heard this morning so far, which I believe is, they have established that he knows people. So this is foundational, and it is boring as a 2-hour word. Why am I bothered of a 2-hour word? It took me 12 minutes yesterday to call Adrian Love Satan's whore. So I don't know why I'm worried today. Whoops. YouTube's, I said Nathan's floor and nothing else. It's my accent. It makes my words sound a bit different. I'm not American, you know.
All right, it's admitted and may be published as you see fit.
370 Yankee.
Me and Young Thug.
You're on this. At this time, I said tender or admit, excuse me, 370 Yankee into evidence.
Any objection to states 370 Yankee?
May I have Mr. Williams?
All right, it's admitted and may be published as you see fit.
Stacy to 369 Yankee.
Same.
You and Mr. Young Thug. You're on this time, stay with like admit 369 Yankee into evidence.
Any objection to states 369 Yankee? All right, it's admitted and may be published as you see fit.
And Stacy to 368 Yankee.
Same.
Is there someone else in that picture besides you and Young Thug?
Let me see. Yeah.
Who, do you know who the other person is?
I know him as a rapper.
What
Uh,
represent?
Birdman.
All right, you're on this time, stay like tender 368 Yankee into evidence.
Any objection to states 368 Yankee?
May I have Mr. Williams?
All right, it's admitted, may be published as you see fit.
And for this round, who do you recognize 348 Yankee?
I'm sorry, what the?
348 Yankee.
It's Glory.
This time, I want to show 348 Yankee. I want to show 348 Yankee on the computer. Mr. Copeland, looking at the computer screen, does the picture on the computer appear to be the same picture that's in front of you?
You say it again?
Does it look like the same picture?
Kind of.
When you say kinda,
Yes,
what
Gigi,
do you
it's
think?
definitely a Swedish
Say what's the
term
difference?
of endearment.
It looked like the same picture.
Okay. Now scrolling in, is this a clear picture for you of who is in that picture?
What you mean?
You said that this was blurry.
Right.
Are you able to see this clearer?
Right?
Who's in the picture?
Young Thug, me, and Shannon.
You know anyone else in that picture?
Yeah, it looked like Lil D.
Which little D?
Lil
Because
D.
there's more than one little D, right?
Yeah, it's the other Lil D.
Okay. How do you distinguish this little D from the other little D? Is this little D from somewhere?
What you mean?
How do you distinguish this little D in this picture from little D that you call your son?
That's my son
Okay.
and Lil D.
Your Honor, this time stay with like the 10 to 60 to 348 Yankee into evidence.
Any objection to states 348 Yankee? Sure. Okay. And you do that though, Miss Hill. Ladies and gentlemen, how about taking a brief comfort break? About 10 minutes? All right? Okay.
All
Ladies
right.
and gentlemen, we're going to be in recess about 10 minutes. All right? All rise.
Strange to take 10-minute break when it's almost noon. But I assume he will go from his 10 minutes, George Glanville's 10 minutes is always 20 minutes. So I assume they will go to lunch quite soon after. Let's move up to live. And there is the state of Georgia seal. Now, as I promised, this is Judge Glanville's decision against Attorney Steele. Hold on. Sorry, Mr. Jingles. Order of contempt and incarceration for Brian Steele. During the proceedings in the above-styled case on the afternoon of June 10th, 2024, one of the two representatives for defendant Jeffrey Williams, Mr. Brian Steele, took the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for this ex parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. Well, of course you did. He called you out on doing something illegal, Judge Glanville. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court found Mr. Steele have repeatedly refused to follow the court's order. And then he cites OCGA this, then he quotes Sivertson, and he quotes, every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. One who disobeys an order or command of the court may be found in criminal contempt. Before a person may be held in contempt for violating a court order. You can see that, yeah. The order should inform him in definite terms as to the duties thereby imposed upon him, and the command must therefore be expressed rather than implied. And the question of whether contempt has occurred is for the trial court, and its determination will be overturned only if there has been a gross abuse of discretion. In my opinion, way over that line. Once an act has been determined to constitute contempt of court, the action the court takes to deal with the contempt determines whether the contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt, to preserve the court's authority and to punish disobedience of its order. Now, remember, most of the afternoon, Mr. Glanville used criminal contempt in order to get Mr. Steele to answer. That is not within the rules of criminal contempt. That is in the rules of civil contempt. So, and it's on the record, and he's still flowering the language. Direct summary criminal contempt, which arises in the presence of the court and tends to scandalize it and hinder or obstruct the orderly process of the administration of justice, the preservation of order and decorum in the court, etc., is exempt from the due process requirements of notice and hearing. How the attorney Steele did his job, zealously advocating for his client because he got notice of an illegal ex parte meeting and the information that was disclosed in that meeting. Is it scandalizing the court? Yeah, sure, because Judge Glanville fucked up. And then he quotes Moody, blah, blah, blah. Accordingly, it is hereby ordered that, pursuant to the court's authority under OCGA, the court holds Mr. Steele in direct criminal contempt for failure to comply with this court's order. It is further ordered that Mr. Steele shall be taken into custody, blah, 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 blah. Yeah, we all will know all this. 20 days served on weekends, which Mr. Steele will serve in the same jail as Jeffrey Williams. What he fails to mention here is how he tried to force Mr. Steele to reveal over and over and over again after Mr. Steele was held in criminal contempt. He is not allowed, Judge Glanville is not allowed to do that. The second he says you are in direct criminal contempt, which was explained to him by Ashley Merchant yesterday. As Papadigos says, he essentially wrote his walking papers because this forces an appeal from Attorney Steele, which has been written for his wife, and Mrs. Steele wrote 2 appeals. And then I also believe that Ashley Merchant either already written one or hasn't filed yet or is about to file another appeal to the appeals court. And I would assume when that gets official, and I will read from that, because that will be extremely spicy, because they have nothing to hold them back anymore. Mr. Steele is already held in contempt. If he kept threatening with it, they might have taken a step back. Okay, maybe he won't, but now he did. Now there's no stopping. This is getting real. Now, as I said before, but let's just read from it. Here is an excerpt from the actual rules. Hold on. There. Let's get that up there instead. In a summary contempt proceeding, objectively observable and describable behavior that causes an articulable interference with the administration of justice must be demonstrably present, which means it has to interrupt. It didn't. The trial has continued. Both the bad conduct and its adverse impact must be set forth with specificity. I didn't read any specificity in Judge Glanville's order. In the ruling by the court, that finds as a matter of fact that no justification exists for the alleged contemner's behavior. Wasn't Mr. Steele justified? I believe he was justified. He got knowledge that there was an ex parte meeting between the judge and the prosecutor where they coerced and colluded to get Woody to keep testifying. And allegedly, in that meeting, Woody confessed. And the judge was prepared to keep that a secret until after the trial. If these procedural steps are taken verbally, as is usually the case with a court trying to restore some immediate order in its proceedings, the judge must, as soon as possible, create a written record that preserves the following. 1. The notice to the perpetrator of the offensive conduct subject to being viewed as contemptuous due to its actual or imminent adverse impact. 2. A detailed description of the bad acts committed or omitted by the perpetrator despite a contemporaneous warning by the court to refrain. 3. An explanation of the deleterious impact on the court's operation or its integrity. The trial continues. This fails on its face. For a recitation of the perpetrator's reason given as justification for the questionable conduct. Judge didn't write down anything about why Mr. Steele acted why he did. 5. A finding of fact by the judge of direct conduct interfering with the court's administration of justice or imminently threatening such consequences. 6. An order declaring the respondent in contempt of court and imposing a statutorily authorized sanction because the order does not sufficiently set forth the words or acts or circumstances upon which the trial judge found. This is from the Schaefer Act. We are unable to review the court's judgment to determine whether the evidence was sufficient for the trial court to conclude beyond a reasonable doubt that Schaefer was guilty of conduct constituting direct criminal contempt for which summary adjudication and punishment was authorized. Glanville State, Bryant. Yeah. So this was in the Schaefer trial. And reading on its face, the appeals court's decision, there's no way, in my opinion, that this should survive an appeal. Now, you never know. Why? Because judges likes protecting judges. That's just a matter of fact. But this is so over the top. I just can't see. I can't see this surviving. And there are Georgia-based lawyers, appellate lawyers, who are all stating the same thing. What the fuck? Well, because I'm not working in United States. I don't have to watch my words. Well, sometimes I have to, because if I say too many bad words, YouTube will demonetize the stream for me. So I have to be a bit careful. Let's see here. Are they back? Nope. Still not back. All right. I assume they are. We will hear so much more, because the prosecution will keep going and keep going. I don't see cross-examination starting until tomorrow. So, folks, yesterday I got a grand total of 2 hours sleep. And so I'm planning on getting right into bed, well, I have to feed the cat first, because if I don't, he will probably eat me instead. And then he will be full for years. Just say them in your native tongue. I tried. Apparently, YouTube have learned Swedish. Now, Swedish curse words are a bit different. We go by religion or farm tools, and in what cavity you can place those farm tools. Stuff like that. So we are quite interesting when we get to curse words. So, regrettably, because I have great numbers today, I had great numbers yesterday, but I need to sleep, folks. I need to sleep. Again, thank you to Dave Umby being a member for 8 months. Thank you, K Squared, for the super generous super chat. Thank you to Zach for your super chat, to Vince for becoming a new member, and to Aussie Overall for gifting 10 memberships. Now, what will happen to you guys? Now, let's see here. I like to redirect. There you go. Let's see if there's anybody interesting streaming at the moment. Broken Baker, who is covering the Karen Reed case, is doing something different today. He is baking an upside down pineapple cake. That could be a good palate cleanser for you all. So I will be sending you over there. But not before saying thank you, guys and gals, for allowing me to do this. Thank you for allowing me to try to interpret this trial to you. And hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. All right? See you tomorrow, folks. Bye-bye.
In the courthouse where time stood still, generations pass on the hill. Prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial we pay the price.